cards. This is an opportunity for individuals wishing to speak on more than one item who have signed up to speak. First speaker is critic Spindler Wayne.
Yes. Item 1, director. The director will have no report today because he doesn't really work here, but he gets paid. Item number 2, we got ourselves a liquor license. Yes, we want more DUIs on Ventura Boulevard. I was there today, and there are not enough people drinking. I need more alcoholic beverage DUIs. And the police endorse it, yes, on number 2, so that they can get more people pulled over and arrested for DUI, because the Van Nuys Courthouse is very, very light right now. I talked to some judges last week, and they said, Wayne, and I said, who? And they said, foo. And I said, yo. And they said, next time you see Jose Weezer, tell him we need more DUIs and get more goddamn liquor licenses. Now, that's why I'm here today. And then number 3, in the CD5, that's that crazy fool Paul Koretz. We got the Avenue of the Stars, a speakeasy. Yes, we love it. And the only thing we want is to amend a friendly amendment, and this is from Marquise Harris Dawson. He not here, but he wants to be able to sell alcohol 24 hours a day instead of the normal hours. So please waive the restrictions. And then, of course, we get all this shit about the Harbor Area Planning Commission. I never can make the meetings. Please, for Christ's sakes, hold the Harbor Area Planning Commission on Sundays at 6 o'clock so I can drive down there and give you all the lovely public comment I'm giving now, as such as calling people scumbags and assholes. And then we got number 6, that fucking Joe Buscaino, that LAFD rat, that motherfucker, no on anything. Finally, anything with David Rue, he's a rapist, fuck him, he just like Kavanaugh.
Okay, second speaker begins with an F, the F word, and a bunch of stuff I don't understand. So we'll skip to Joe Jimenez. Sir, you are not Joe Jimenez.
I signed up as Joe Jimenez. Brown Act says you don't have to technically put your name down, but I wrote up as Joe Jimenez, fool.
City Attorney, what is your advice on that?
He can speak.
Okay.
Goddamn right I can speak.
Joe Jimenez.
So, as you heard, dumb motherfuckers want to provide us with more public alcohol, and I'm all for it. I am for Ventura Boulevard to consume on the sales of more off-site alcohol, because we just need Jose Weezer's bar in our community. Again, on item 3, Peppa Pig. And what does he want? On-site sales of alcohol beverages. We should have hookah shops and marijuana medical shops, all in convenience and necessity for dumb niggas who don't know how to read my name for the public comment card. Then I'm on item 6, because I like the number 6 under Joe Blow, who's asking for conditional use permit for development. Well, you know you niggas don't know what development's about. The only way you know money on development is shove the goddamn money in a brown bag and kick it under the table to development. That's why Joe Buscaino ratted out Janice Hahn. And by the way, who fucking wants 32 bicycle parking spaces when you have conditional use for the homeless, the disabled, and the elderly that need parking, you stupid dumb schmuck? And then look, live and work units. How the fuck do you want to live in CD14, live and work, when you got to work 3 motherfucking jobs and then sell your ass on the sidewalk with your vertugas? You see, Jose Weezer and his dumbass wife are running for re-election in CD14. I suggest you vote for that dumb bitch now. Regarding restaurants and retail use directly accessible, I find that offensive. Not that I'm saying anything bad, but it is a good recommendation to provide parking spaces for full-level parking, nigga.
Okay, we will now, sir, if, let that be your first warning. If you disrupt this meeting again, we're going to have to ask you to leave. Thank you. We will now move on to the remainder of the the agenda. First item, the consent items are item number 2. We have no speakers, so we will move item number 2 on consent. Item number 3, we could move on consent. Item number 4, move on consent. Item number 5, we could move on consent. And item number 6, we will continue to 11/27/18. And any of those items, any objections? Seeing none, so ordered. Item number 1, report from the Director of Planning, Mr. Bertoni.
Yes, thank you, Chair Weezer, and members of the Planning and Land Use Management Committee. Vince Bertoni, Director of Planning. Just real quick, we're in our ongoing effort to update our community plans. We've been out in the west side of Los Angeles most recently, and we'll be moving and starting to do some of the initial outreach in the harbor area. So what we've been doing is we've been continuing our Planning 101 series where we reach out to the community to give them information in terms of how the planning process works. So we've been doing a series of those focused on the west side regarding community plans, and that really has gone hand in hand with our initiation of our outreach in the west side areas. We're now moving that down into the harbor area where we're updating the plans in that area, which includes Wilmington Harbor Gateway, we've gone down into the harbor area. The next area we'll be looking at is our Southeast Valley, because that's the next group of plans that we'll be updating. They are doing Planning 101 as well as community outreach, initial outreach for the community. So we're really starting up and running with getting all the initial outreach to get up and running the plans in the west side, west of the 405 freeways, south of, in essence, Santa Monica, as well as the harbor area in the Southeast Valley. So those are up and running, so you should be hearing from that as the community starts to get engaged. With that completes my report, and I'm happy to answer any questions.
Thank you, Mr. Bertoni. Any questions? Okay. Seeing none, we will receive and file the report. Thank you again. Item number 7, if you could call that to order, Mr. Mejia.
Item 7, Councilman, this is a motion. Weezer Harris Dawson is instructing DOT, City Planning, and Public Works to report back on the process for capital improvement planning in downtown LA and other instructions.
Thank you. For the record, we've been joined by Councilmember Englander. And is staff here to present on this item?
Hello. Good afternoon, council members. Karina Macias from the Department of Transportation.
Eddie Guerrero from Department of Transportation, Development Review and Planning.
So we would like to request the motion directives number 3. They could be amended to direct the controller or to authorize the controller to transfer and appropriate the $250,000 from the CD14 Public Benefit Trust Fund to Fund 50Y in an account to be determined by LADOT for fiscal year 2018-19 to cover the cost of consultant services to develop and execute an engagement strategy, define a project list, and identify a funding strategy for a downtown LA capital improvement plan. Additionally, we would like to request a 4th directive to be added that would direct LADOT to prepare and release a task order solicitation for consultant services to develop a funding strategy to implement the infrastructure improvements that are identified that serve increased population growth while satisfying sustainability goals and providing safe and attractive travel choices, subject to a Charter Section 1022 determination. Thank you.
Great, thank you. Does that conclude your presentation?
Yes.
Okay, thank you. Just as background, this motion's genesis came about as we were examining and continuing to talk about the growth of downtown Los Angeles, and it appears that the public infrastructure portion and transportation circulation patterns are outdated to be able to accommodate the growth. We have about 75,000 people who live in downtown today. Our forecast estimates that we will add 140,000 by the year 2040. On top of that, given the additional types of entertainment venues we are creating and new visitors, it's incumbent upon the city to start planning ahead for the infrastructure needs of downtown as well as traffic. And so this motion tends to start looking ahead. Quite frankly, we're catching up because the growth came before the city started to implement some of those public infrastructure and transportation improvements. But at the minimum, I think we should begin to look at the existing traffic patterns that we've created that are based upon the 60s and 70s and are way outdated. There are new circulation patterns that we need to catch up with where the growth is and where to move. And so hopefully we'll get back some information to be able to make those changes along with a financial plan that we could implement and know where to tap into some money, be it federal, private, or state, whatever it may be, so that we could move forward with this. So thank you for your work on this. Yeah, Mr. Price?
What's your timing on this report back? Just kind of curious.
Good question. What's the timing on the report back?
We've currently developed or drafted a scope of work for to implement the directives of the motion, so we anticipate a pretty quick turnaround of potentially 90 days.
90 days to be back with the report?
Or
longer,
Well, I think you'll be back with the initial approach.
The initial
and then
approach.
we're going to be able to
That's
go
right.
to an RFP to
Or
do the
task order
traffic studies
solicitation
and
process.
everything
That's right.
else, right? So within 90 days, you can come back and outline
An action plan,
an action plan. Yeah.
precisely.
Okay. Great, thank you. Any other questions? No. Seeing none, we will approve this item and we will incorporate the amendments as proposed by the Department of Transportation. Correct, Mr. Mejia?
Yes, sir.
Thank you. Any objections? Seeing none, so ordered. Item number 8.
Councilman, item 8 is a resolution and a general plan amendment, a draft ordinance for a vesting zone change and a high district change for 475 live-work units, which include affordable housing in CD 14.
Thank you. Is staff here on this item?
Good afternoon, council members. Sergio Ibarra, planning staff. At its meeting on July 12, 2018, the Los Angeles City Planning Commission approved CPC-2016-3575 for the 668 Alameda project, which is a mixed-use development consisting of 475 live-work units, totaling approximately 516,101 square feet of live-work floor area, and approximately 61,200 square feet of ground floor commercial uses. There were no appeals to this action, and city planning staff is available for any questions. Thank you.
Great, thank you. Are there the applicant and the representative, the applicant, Mark Janda?
Good afternoon, councilmen. My name is Mark Yonda with
Pick
Avalon.
up the microphone, please. Thank you.
Yeah, my name is Mark Yonda with Avalon Bay Communities. Just really want to express our gratitude to city staff and the planning department, the councilman's office for guiding us through this process. I really appreciate all the input that we've received throughout. I think it's made the project a better project. Also would like to thank our neighbors in the community. We spent a lot of time meeting with them and listening to their concerns and responding to those in the design of the project. And I think we have a project here that will be an asset to the community over the long term. I'm here with Edgar Kaladian, who has a few words to say too from our team.
Great, thank you.
Thank you, Mark. Edgar Kaladian with Mayor Brown here on behalf of the applicant. Thank you, council members, and a special thank you to planning department staff for working with us through this project. We're very excited to bring a great project to the Arts District. Out of deference of time, I'll keep my comments brief and note that we submitted a letter dated September 19th, 2018 through the city clerk proposing certain modifications to the conditions of approval. We respectfully request the Plum Committee recommend the conditions be amended appropriately, and we are happy to answer any questions the committee members may have. Thank you.
Great, thank you. Chelsea Byers, Ruth Myers, and Vivian Riscalvo. Chelsea, not here. Ruth, not here. Vivian?
Good afternoon. I'm Vivian Riscalvo, and I'm here on behalf of CCA. We strongly support this project. It's important for the district. It provides housing, affordable housing, including public arts and community open space. So we're just here to ask for your support, and we are very happy that this type of project is going into to the Arts District. Thank you.
Thank you. First of all, I want to thank the applicant for working with the community and ensuring that the industrial and artistic feel of the Arts District in downtown LA remains intact. Also for adding much necessary housing to the city, as well as bringing some necessary commercial and retail to the area. It's a very special area, and your approach to this, well, initially not all agreed upon, but eventually we got to a place where it makes sense for the community and the district. So I want to thank you for your cooperation. And as far as the letter goes to the file requesting various conditions be amended, have you had a chance to look at those? Are they okay with you? Anything stands out?
Yeah, they're just clarifications of existing conditions.
Okay. And we also had a request that the applicant provide $2 million to the CD14 Public Benefits Trust Fund for future improvements to the district. For example, we just approved a motion for $250,000 that will improve the circulation plans for an infrastructure for downtown LA, with a portion to be provided at the issuing of building permits. Is the applicant okay with that? Okay, thank you. So any other further questions or comments? No, I'd like to move to approve this project with the following amendments. Amend the conditions of approval, excuse me, consistent with the changes requested by the applicant in their letter dated September 19th, 2018. Require that the applicant provide $2 million to the CD14 Public Benefit Trust Fund for future affordable housing, homeless services, transportation, or streetscape improvements, or other public serving community benefits within CD14. A minimum of $500,000 shall be paid no later than 60 days following the end of the entitlement's appeal period. Planning amend the conditions of approval such that all conditions are consistent with those amended by this committee and adopted by the City Council. Okay, that's the motion. Any objections? Seeing none, so ordered. Thank you. Next item is item number 9.
Item 9, Councilman, is an appeal filed by Lucille Saunders and the La Brea Willoughby Coalition. It relates to the approval of a vesting tract map to demolish a triplex and to construct 5 small lot homes in CD 5.
Thank you. Welcome.
Good afternoon, Plum Committee. I am Kevin Golden, City Planner and Deputy Advisory Agency. This is the second level of an appeal, and it's by an aggrieved party, Lucille Sanders, from the La Brea Coalition. And the appeal was made on 2 points, and I'll briefly go over them. Appeal point number 1 was that the approval of the front yard setback is inconsistent with the R3 zone. Staff's response to that is that at the time of filing and at the time the case was deemed complete, the approved front yard setback was indeed in compliance with the minimum 5-foot front yard setback requirement by the small lot ordinance. And what was approved by the advisory agency was actually a 10-foot front yard setback. The approval was sustained by the Central Area Planning Commission. Appeal number 2 was the Approval of the additional height for the placement of the safety guardrails along the proposed roof deck is inconsistent with the 1XL height district limits. As part of the request, the applicant requested an adjustment for a building height of 33 feet and 6 inches in lieu of the maximum height of 30 feet in the R3-1XL zone. The advisory agency did not approve the over and height request. The request was denied, and the decision that was made was sustained by the Central Area Planning Commission. Staff recommends that Plum Committee sustain the denial of the over and height request. So in conclusion, in consideration of the foregoing, it is submitted that the Central Area Planning Commission acted reasonably in sustaining the decision of the advisory agency approving vesting tentative track map and denying the height adjustment request. Staff recommends that the City Council deny the appeal, sustain the action of the Central Area Planning Commission, adopt the findings, and determine that the tentative track map is categorically exempt from CEQA. And that concludes my report. Thanks for listening, and I'm available, and we are available for any questions.
Great, thank you. A basic question. The Central Area Planning Commission reaches out to the west side under Koretz's district?
No.
Okay, so how was this? Can someone explain how this happened?
Actually, the Central Area Planning Commission has an area that goes almost to the west side. I think the border is La Cienega, if I'm not mistaken.
It just stretches out there. Yeah.
Right. So it does cover this
Maybe
area.
it needs a new name because that's not central to me.
This is Kevin Keller, City Planning. They're based on our community planning areas, so it includes the Hollywood and Wilshire community plans, which both include a modest amount of CV5, Council District 5.
I see. So once it captures some of it, it captures the whole area, the whole...
They're by the community plans.
Community plan?
Yeah, correct.
Okay. I see. Okay, thank you. Any questions or comments from the committee? We will turn to public comment, and the appellant on this item is Lucille Saunders. Ms. Saunders, you have 5 minutes, and the applicant has 5 minutes, and all other speakers have 1 minute.
So will my team have 5 minutes?
It depends. You could include your team into the 5
No,
minutes
my
as you
attorney.
wish, but they also have their individual right to do 1 minute, so you could distribute that as you like.
The La Brea Willoughby Coalition, which supports new projects that follow all codes and regulations, filed this appeal to shine a bright light on the Department of Planning, VTT, and the CAPC processes. Public input has been greatly truncated since ZA hearings were deleted in VTT hearings, and public review of this case files exposed citizens' documents were missing before the hearings. Most grievous, the city set a precedent with findings that don't fit the facts nor follow and enforce its own codes and policies. The Hollywood Community Plan Objective 3 states to encourage preservation and enhancement of varied and distinctive residential character of the community. And zoning code R3 front yard setback is 15 feet, which governs this community, governs this setback, not the small lot subdivision ordinance. So the burden is on the beleaguered citizens to fight these cases through legal means to maintain our neighborhood rights and quality of life.
My name is Sabrina Venskis, and I'm the attorney for La Brea Willoughby Coalition. And the issue in this matter is that the AA misunderstood the law and misapplied the law. It's wrong as a matter of law that the small lot subdivision is not required to comply with the front yard requirements of the underlying zone. It actually is. The small lot subdivision provides that within the small lot subdivision itself, there's no setbacks that are required. But along the street, the R3 zoning setbacks apply. And the R3 zoning setbacks here are 15 feet. That's what's required. 10 feet is what was approved. That's wrong. It's wrong as a matter of law. They're applying the zoning code incorrectly in the small lot subdivision ordinance, at least at the time that this application was complete, is being construed incorrectly as a matter of law. As a matter of fact, the AA made a determination that the prevailing setback along this block is 10 to 13 feet. That is wrong as a matter of fact. And in the record, there's much testimony and evidence that the prevailing setback is 15 feet, at least 15 feet on this block. So as a matter of law and a matter of fact, this AA made a mistake and it needs to be corrected by this body. I would like to keep the rest of it for my rebuttal, please.
Okay. Keith Nakata, are you the representative for the applicant? You are not. Okay. Do we have the applicant here? Under what name? Alia Thompson. Okay.
Hi, good afternoon. Elia Thompson, and I represent the owners of this project. I'm going to be very brief. The small lot subdivision governs small lot projects, period. Can't pick and choose what code you want to look at and how you want to look at and where you want to look at that suits what you're trying to go for. The small lot subdivision governs small lot projects when it was in place at the time in which we filed and at the time in which this project was deemed complete. The front yard setback was 5 feet. The city planning department does have the discretion to demand a greater setback, and that's what they did. They demanded a 10-foot setback. We also have a 3-foot dedication, so we are technically 10 feet, or 13 feet back. We did have a request for some railings to have rooftop deck. That was not approved. We did not appeal it, so anything in the appeal relating to that is moot at this point. So again, I just want to reiterate that the small lot subdivision governs all yard setbacks, all portions of a development that is a small lot development, period. And if you're not a small lot project, then you are required to go by the yard setbacks in the underlying code on which your project is located, which in this case would be the R3. But this is a small lot project, small lot subdivision. We were in place, complete, at the time in which the old small lot subdivision was governing, and therefore a 5-yard setback would be fine. But certainly the city demanded 10-yard setback is more than fine. And like I said, when you add in the 3-foot dedication, 13 feet is the total. Thank you.
Thank you. What is your name, sir? Did you sign up to speak as well? No? Okay.
He just told me I covered it. Thank you.
Okay, thank you. Keith Nakata, and then Sabrina Venskes, Ursula Ortiz, and then we'll hear from Council District 5. Keith Nakata?
Good afternoon. I have a question for the chair. I didn't see an item for the neighborhood council comments on your agenda today.
Okay, you're signing up as speaking on behalf of the neighborhood council?
Yes.
And is there a, what do you call it? One of those? Thank you, Mr. Bloomfield. Community
Mr.
impact
Chair,
statement.
I don't see a community impact statement on file for this item.
Unless we have a community impact statement where you have 1 minute. Yeah, because the community impact statement ensures us that it's an action by the neighborhood council. You're here speaking as their representative. So
I can submit the document, sir.
You have it right now?
It's already been in the file.
Sure, sure. Okay, we could take that now.
But I'd like to read it into
the community impact statement.
The letter that we submitted as part of the project originally.
Okay, go ahead. Yep.
Okay, can you reset my time, please?
Sure.
Thank you. So it says, Dear Mr. Dacey, we appreciate the opportunity to comment on this application as a certified neighborhood council serving the area in which the project is located. Actually, I should first start by saying my name is Keith Nakata. I am the co-chair of the Planning and Land Use Committee of the Mid-City West Community Council. The Mid-City West Community Council Board of Directors approved the following motion unanimously, 21 yeas, 0 nays, 0 abstentions at the Tuesday, December 12th, 2017 board meeting. The Mid-City West Community Council opposes the project as proposed oppose due to the following reasons. Incompatibility with the small lot subdivision guidelines. The front facade is dominated by a garage and otherwise does not present a visual front door to the property. The presence of a garage for the front unit requires its own driveway in addition to the driveway to access the other units' garages, creating a minimum of a 20-foot wide width of driveways across the front yard setback, resulting in close to 50% of the front yard as pavement. Does not match the prevailing front yard setbacks along Poinsettia Place. Incompatibility with the queue condition on this property, limiting the height specifically to 30 feet without making any findings for the need for the adjustment. The destruction of rent-stabilized housing. And lastly, an unwillingness to work with the neighborhood council and the surrounding community on improving the project. Thank you for your attention on this matter. And it's signed Keith Nakata and Mehmet Burker. Just to go to what has transpired since that time, the front yard setback remains less than the required 15 feet in the R3 zones. The front yard is nearly 50% covered in concrete by two driveways, and it's one of the worst designs we have seen in our area. Thank you.
Thank you. Ursula Ortiz.
My name is Ursula Ortiz. My neighbors who are working today and could not come to the hearing asked me to present their letters to you in support of the La Brea Willoughby Coalition's appeal to maintain the zone code 15 feet front yard setbacks in our neighborhood. Thank you.
Thank you.
To whom I hand the letters? Yeah, thank you.
Aviv Kleinman, Council District 5.
Good afternoon. My name is Aviv Kleinman, Planning Deputy for Council District 5. Councilmember Koretz has been closely following the appeal case at 838 North Poinsettia Place. He sympathizes with the neighbor's desire for a uniform setback along the block, along with the design concerns some neighbors have posed. However, we understand that there is no justification to oppose the setback as presented. This is because the applicant filed their VTT vesting tentative tract map application while it was deemed complete under the old 5-foot setback buffer rules. Although the revised requirements mandate the setback to the underlying zone, those rules do not apply to this project. It is important to mention that the applicant volunteered a 10-foot setback, and it coupled with the 3-foot dedication that brings the project to 13 feet back from the existing curb. Therefore, Councilmember Koretz aligns with the Central Area Planning Commission's decision and does not object to a denial of the appeal. Thank you.
Thank you. Any questions or comments? Just to ask staff and to be clear, did we have you speak on your 1 minute?
You didn't, except I had asked for a rebuttal. I had saved 2 minutes for rebuttal.
No, we don't do that here, but...
Oh, okay. Can I have my minute then?
Sure.
Thank
go
you. I
right ahead.
appreciate that. Is now a good time?
Yes, right now is a
Okay.
good time.
So there's a reason why the old small lot subdivision, which is what this application goes under, says that it states no front, side, or rear yard shall be required between lots within the approved small lot subdivision. So that has to do with between the actual units. It doesn't have to do with the frontage on the road. That's why the ordinance is silent with respect to the frontage on the road, the front yard setbacks. We're talking about a 15-foot yard setback from the actual street onto the back. And the old small lot subdivision ordinance is silent on that. I just litigated this issue in another case. We didn't actually get a formal ruling on it, unfortunately, because we got it thrown back. The judge threw it back on procedural grounds and made the commission go and look at it again. But the point is that the old ordinance does not state it's a 5-foot setback or no setbacks from the road. It's actually the prevailing setback in the R3 zone. So it's a misunderstanding of the way the law is.
Great, thank you. And the staff addressed the issue that it's the prevailing setback on the R3 zone?
What I'd like to clarify is that under the old small lot ordinance, the words front yard setback, true, is not used precisely for the front of the development, but there is a requirement, or there was a requirement for a 5-foot buffer along the perimeter of the entire development, which in effect ends up being a 5-foot front yard setback, and that was what was required at the time of the time that the case was deemed complete. So the 10-yard front yard setback actually exceeds the minimum requirement. The applicant originally brought the request for a 5-foot buffer, but just to be more compatible with the neighborhood, I requested, or the advisory agency requested, a revised map to provide 10 feet.
I see. And on the height, the appellants say that shouldn't be approved. Can you just comment on that?
Okay, the height actually was denied, so it was not approved.
It was not approved.
It was not approved, and I'm not sure why there was a misunderstanding there. But the height of the buildings are, they meet the maximum 30-foot requirement of the 1XL height district.
Okay. Yes, City Attorney?
Terry Kaufman, Macias City Attorney's Office. Just to clarify, the case that Ms. Venskis was talking about is Cohn versus City of Los Angeles, and that case, as she said, was not decided on any merit, so no court has ruled on this issue that we've been discussing with the setback.
What's called an unpublished case, or what's?
No, it was decided on a procedural ground relating to an appeal and had nothing to do with merits whatsoever.
Okay. Thank you. So with that, any other questions or comments by committee members? No. Given the testimony and the recommendation from Council District 5, we'll move to deny the appeal and sustain the Central Los Angeles APC's determination in approving the vesting tentative track map and related CEQA findings for the project. Any questions and any objections? Seeing none, so ordered. Thank you. Next item.
Next item, Councilman, this is a haul route appeal filed by Nancy Myers and other individuals, part of the Bel Air Association. It relates to the export of 3,074 cubic yards of soil for the property at 11667 West Bellagio Road in CD5.
Okay. So is staff here to present this item?
Good afternoon. Veronica Lopez, Department of Building and Safety. This item was originally approved August 28, 2018 by the Board of Building and Safety Commissioners, adopted staff report recommendations as board action for a total export of 3,074 cubic yards. This item was originally approved on July 12, 2016 for an export in the amount of 2,874 cubic yards. At the August 28 hearing, the applicant had returned for an additional 200 cubic yards. 30-day notification intent to excavate is the first item on the appeal. The determination as to whether a 30-day notification is required is done through the plan check process. This item is outside the scope of a haul route. The second item is in regards to the environmental report prepared by City Planning. A representative from City Planning is here to answer any questions. Items 3 and 4 on the appeal are in regards to inspection, investigations, and approved soil reports, respectively. Senior Inspector Dan Schneiderit and Adolfo Jesus Acuesta from Grading Division are here to answer any questions on this item.
Thank you. Nancy Myers? Or the appellants?
of the neighbors that are adjoining to this project. Can you hear me okay? Thank you. I'm an adjacent neighbor located next to the project. I believe the mitigated negative declaration is inadequate and does not constitute a sufficient document to support the approval of the project. I wanted to provide you with a little history of our hillside. My family has owned our house on Estrelita Way for over 60 years. In 1966, there was a major landslide that occurred from above on Linda Flora Drive. The street above our house came down and covered Bellagio Road and Estrelita Way for days. So we know this hillside moves around a lot. We believe the geotechnical report that was written by Applied Earth Sciences and Caro Minas is flawed. We believe, well, Susan Naylor, one of the adjoining property owners, retained the services of a consulting geologist so that she could rest assured that she was safe from hillside failure due to this project. The consulting geologist she hired is very familiar with this area. Her geologist reached very different conclusions than the report supplied by Caro Minas of Applied Earth Sciences. The report was sent to LADBS accompanied by a letter from her attorney. LADBS passed it along to Applied Earth Sciences, who responded to comments. Susan Naylor's geologist also responded to comments with a very different outcome. It's to be noted that Caro Minas, owner of Applied Earth Sciences and author of Mr. Nazarian's geotechnical report, had his civil engineering license and his geotechnical engineering license suspended for 2 years on March 8, 2012 by the Board of Professional Engineers, Land Surveyors, and Geologists. The charges were for committing deceit and fraud and that he made misrepresentations during the course of providing engineering services. The charges also read that the respondent did so by providing conclusions in his engineering inspection report that were not supported by data. Mr. Nazarian has numerous complaints and violations from this project. We have no assurance that the hillside has been stabilized properly. We have no assurance that the plans have been followed. We have no assurance that the caissons are the correct size or even reach bedrock, and we're very concerned about our safety. The last note, in the spring of 2016, 3 adjoining neighbors began experiencing cracks in our homes, inside and out. The inspectors from LADBS visited our homes and determined that the cracking was due to the substantial amount of rainfall in Los Angeles that year. And it seems that that was just a coincidence that our houses started cracking just 6 months after Mr. Nazarian began excavating the hill. Our houses have stood the test of rainstorms and earthquakes for years, so I find it hard to believe one rainy season could change our houses so drastically. I want to express my extreme concern about the stability of the hillside and the safety of our homes and families, now and in the future. I feel the geotechnical report submitted by Applied Earth Sciences is not substantial and was not reviewed adequately by LADBS before passing the mitigated negative declaration. I'm not satisfied with the response to comments supplied by AES regarding the consulting geologist report. The permit was issued without proper consideration of the significant and unavoidable impacts as required by CEQA. Thank you for listening to our case, and I hope that this committee can find resolution and provide for a safe project and our safety for our homes and families. Thank you.
Karush Alex Nazarian.
Good afternoon, I'm Alex Nazarian. As far as the geological report, the city already compared ours to theirs and they took ours in favor. As far as the haul route is concerned, it's complete, so we have nothing else to move at this point.
Okay, thank you. Do you wish to speak, sir? No? Okay.
Good afternoon. My name is Kurosh Nazarian. His geologist even didn't come to the land, make any examination and test. And he wrote one report, I believe is not correct. From first day I start to work in this project, at least 1,000 times she called to the city, different department, and also his son came and with his car blocked the road. One time, post lady was over there voluntarily. She came to me. She gave me this one paper. She says, if you have any help, I will be there. The second time, he blocked the road. My deputy went to talk with his son. His son back up on him. He called the police, and police show up, and they give them warning. And at least I hired 4 different contractors, and in the middle of the job, they send me letter. They says we don't want to work with you because the neighbor it bother us, and every day she come and says bad word, and that's it. Thank you.
Thank you. Bruno Naylor, Susan Naylor.
Hello, I'm Bruno Naylor, neighbors of the 11667 Bellagio site. The same person he called the police on. The main thing is we've basically just been trying to report and have documentation to show what's been going on because we are uncomfortable with the safety of the matter, and just from our geologist report, maybe the city did take the other report, but we wanted to continue if there was violations to take photos and document and do everything by the books. But the real reason that we're here, and we're hoping that you guys will hear us, is that we just want a third-party geotechnical review and potentially study that would just show us that from the point of that last study to today, how much dirt has and soil has actually been removed. A lot of the violations that took place were all in line with hauling and everything else. So I just wanted to make sure that we knew how much soil and dirt has actually been removed. That was.
Thank you.
Thank you.
Susan Naylor. And after Susan is Hagu Solomon Carey. And then Sean Bayless.
I'm the neighbor right next to the 11667 Bellagio Road. Can you hear me? And at the very beginning, I live 300 feet from there, and I was never notified of anything going on there. I'm within the 30-foot radius, and I never got a notification. I never got a certified letter. Just one day saw them up there building. And I'm very upset about that because I think that we should be notified that something's going to happen and they're going to, tear down a hill that's right adjacent to my house. If you look at the site, you've never seen a site that looks like this site. It looks like a war zone. So number one, I had a geology report made, and I thought he was going to say everything was fine, and he said that there were landslides there. It's made out of Chico rock. It's very, very dangerous, and it shouldn't be built. So I showed it to the city. The city said it was okay, and so we feel upset about that. And then the Nazarians are, I don't know how qualified they are to do the building, and I don't think they have a contractor that does the building. So they just sort of, it's Mr. Nazarian and his son, and in general, we just feel very unsafe having them even be the builders. Thank you.
Sean Bayless, Hagu Solomon Carey, both of you from CD5. Hagu Solomon Carey from CD5? No? Okay. Are both of you from CD5?
No, I'm no longer with the office, sir.
Okay, all right, there you go. That confused me.
Sorry. Sean Bayless, I'm the executive director of the Bel Air Association.
Oh, cool.
So there's a lot of history to this project. So much history that and questionable behavior that the project was actually shut down by Building and Safety for a number of months. I had a speech kind of prepared, but I want to hit on something that the applicant or developer had just said, that there's nothing left to haul. It's all been hauled today. They completed it. So they either hauled the 2,874 cubic yards, which was a part of their original haul route, and no portion of this additional part of the haul route, or they did haul some of the additional haul route, which is currently under appeal, which they weren't supposed to be hauling that dirt. So either here is a moot issue because they didn't need that 200 cubic yards, or they did move that 200 cubic yards when they weren't supposed to. And this is part of the issue. Every report we get from neighbors, from other staff, is that they don't care about the rules. And so we would ask that it be denied until a third party geotech can review how much soil has actually been removed and the stability of the hillside. But again, I think, unless I heard incorrectly, the developer just admitted that he broke the law again.
Thank you. Final speaker, Hagu Solomon Carey.
Thank you, Hagu Solomon Carey, Council District 5, Planning Deputy. Council District 5 supports the Plum denying the haul route appeal for exporting a total of 3,074 cubic yards of earth total from the project site located at 11667 West Bellagio Road. With that said, we do wish we could support the appeal because of the concerning actions that have been reported to you today, but we cannot justify upholding that appeal for the following reasons. The issue of due process, on the issue of due process, this appeal is for the haul route and not for the notification of intent to excavate. Further, we feel that the appellants have had an opportunity to engage in the appeal process for the haul route, which includes excavation activities evidenced by this appeal. On the issue of the MND and subsequent addendum, we feel that it is in line with the soils report reviewed by DBS dating back to July of 2014 all the way through January of 2017, including the third-party review of the initial soils report, thereby supporting the less than significant impact found in the MND. On the issue of reporting the cause for the increased grading amount, we feel that DBS's review of the log on site, noting the hauling activity is sufficient for documenting hauling quantities, and the request for more earth movement can be a necessary avenue for correcting initial calculations. This appeal assumes that the miscalculation is due to a dangerous error, but that may not always be the case. With regards to multiple violations, upon further review, we have found that there are no current outstanding code violations. Now, with all this said, and due to these multiple violations, we ask that the Department of Building and Safety closely observe the enforcement of the conditions stipulated in the report dated August 15, 2018, and the MND and subsequent addendum. We also request that Department of Building and Safety keep our office informed of any activity that violates the conditions outlined in the above documents. Thank you.
Thank you. Any questions or comments? Okay. So given the testimony of Council District 5, we move to deny the appeal, sustain the application to export 3,074 cubic yards of earth, and adopt the mitigated negative declaration and mitigation monitoring program for the property located at 11667 West Bellagio Road. And also, we could further request that we incorporate the request made by CD5 that you monitor this, both the conditions and the MND as it proceeds. Any objections to that?
Also adopt the addendum, Councilman.
And adopt the addendum. Okay. Any other questions, comments? Seeing none, so ordered. Thank you. Next item.
Next item, Councilman, it's also a haul route appeal filed by Kate Blackman and others as it relates to exporting 3,000 cubic yards of soil for the property at 1104 North Tiger Tail Road in CD 11.
C&L Kanawi Building and Safety. This haul route was heard on August 28, 2018 by the Board of Building and Safety Commission, and they adopted the staff recommendations as board action, found the project categorically exempt. The items in the appeal address the narrowness of the street of Tiger Tail and the categorical exemption. This project is located on a standard street with no parking signs posted on the side adjacent to the project site. As such, DOT and Building and Safety staff did not require additional no parking signs. However, a condition was added in the report to indicate only one hauling truck is allowed at any given time on Tiger Tail Road and Kenter Avenue, as well as a flag attendant to be located at that intersection and to assist with ingress and egress from the project site. City planning is available to answer any questions you might have with regards to the categorical exception. Thank you.
Great, thank you. So we'll turn to the appellant, Kate Blackman.
Hello, I am Kate Blackman, and I am president of the Neighborhood Association, but I am also a neighbor to this property in question. I just want to say also that I am appealing the ruling. We weren't sure what to check on the thing, so I just want to make sure it's noted what my position is. My house is fronts Tiger Tail and is less than a quarter mile down from the excavation site. Myself, the other appellants, and more than 80 surrounding neighbors are very concerned about the impact of the proposed haul. The amount of dirt to be hauled will fill something like 300 trucks. There are already 600 construction projects on Tiger Tail, one of which is directly above this project. Another project further up will also be looking to excavate. We are on a narrow road that dead ends, and I have some pictures of what Tiger Tail looks like. There is no alternative route or outlet above Deerbrook Lane, which is below where I am on Tiger Tail, to divert traffic. This will greatly hinder access. It already takes an emergency vehicle 10 minutes to reach the top of Tiger Tail, and this road is the only emergency access to homes. BW Partners has been comparing this project to one at 717 North Tiger Tail. We have photos there of trucks accessing that property. I have a photo of a hauling truck just on Wednesday that was blocking the road, and you can see how challenging it is for neighbors and walkers to navigate around the trucks. We appreciate that they have considered making one truck go up the road at a time, but there's a picture that shows a typical day that involves all the other construction properties. Today, for example, we counted 100 trucks on Tiger Tail. We are at capacity. Navigation on Tiger Tail is increasingly challenging and more unsafe. Safety and congestion would be greatly impacted by the approval to haul the 3,000 cubic yards. We would like an environmental impact report to be done, as was done for 717 Tiger Tail, and that the hauling be limited to 1,000 cubic yards, about a third of the current proposed project. Thank you.
Thank you.
Can I take some of your time?
Sure. What's your name?
My name is Corey Buckner. I'm an architect and historian, and I've actually written a book about the community where this project is located. I'm also a resident of that community. I have also worked on about 24 of projects in this Crestwood Hills area. I'm currently working on one that's about 7 houses away. We excavated for a 1,000 square foot basement, and that was 131 cubic yards. This project is proposed to be 3,000 cubic yards. I don't know who is approving these and waiving CEQA. 3,000 cubic yards means 300 trucks of excavated earth. That's a lot of trucks to go down a very small street, and we're all concerned about this. The project proposed is approximately 10,000 square feet. The typical houses in our area are about 2,400 to 4,000 square feet. We have an architecture committee that approves houses. This is way beyond anything that will be approved. If we limit the amount that's to be hauled, we will guarantee that there will be a smaller project. The other issues that should be considered are the fact that the project is a designated seismically induced landslide hazard zone, and this is according to the city's grading pre-inspection report. And also at least one large oak tree has been removed. We have pictures of that, and there's pictures at the house when it was just sold. So obviously this is a developer who is not concerned about maintaining city laws or our particular architectural community, architectural committee requirements. Thank you.
Good afternoon. My name is Mitchell Reiner. I am the next door neighbor to I'm at 1046 Tiger Tail. The north side of my property, which is in the slide area, is adjacent to the subject property. Having very little peace and quiet and enjoyment on Tiger Tail has been a difficult thing with all the projects that are going on. This project will just further impact us for another couple of years. Also, I have a 13-year-old with respiratory challenges, and knowing that the amount of dirt that's moved will create some problems for her also. I appreciate you letting us have some time here today.
Thank you.
May I have another minute? I only need a couple.
Yes, you can
I'm
speak
Cory
to your
Buckner.
one individual minute now. Yes, go ahead.
I just wanted to emphasize if we could possibly have the CEQA considered and an environmental impact report produced and addressed to the public concerns that we have. I think that's a reasonable thing to ask for. The amount of disruption that this particular project will cause is massive for our community, and we do request that. Thank you.
Thank you. Clark?
Hi, my name's Clark Bronstein. I have the owner, Philip Bronstein, who's here, I think submitted a car as well for the property as well as the applicant. So,
Okay, and the applicant's name is Carolina?
Carolina, yes.
Yeah, we don't have her on here, but, okay.
I could have the owners here as well,
Okay.
of BW Partners. So
We have 5 minutes, however you want to split that up, it's fine. And can the Department of Safety move to the side a little bit, please, so I could see the clock? Thank you. My apologies.
Hello, good afternoon, Plum Committee. My name is Philip Bronstein. I'm the owner of 1104 Tiger Tail. This is Carolina Pineda. She's the applicant for the project. The property at 1104 Tiger Tail consists of an existing single-family residence. We are looking to build a new residence on the site. The concerns that the neighbors are raising, I don't feel are justified. Tiger Tail is a 40-foot wide standard street. I drove up there this morning. It's quiet, it's calm, it's not congested. Of course, in front of a house where construction is occurring, there's additional work trucks parked like any other construction zone. And we have a soils approval letter. The seismic issues, slope stability have all been addressed. It's approved. Our stabilization of the site will be enhanced by the project, and the concerns they raised about an environmental impact report also not justified. The project is categorically exempt, and like I said, it's an existing single-family residence. We're just replacing it with a new one.
Thank you.
We also have our grading engineer here if there's any additional questions or if you have anything else.
The site is going to be enhanced by pile foundation system, so it's going to be beneficial to the slope stability. So we should have no concerns about that. And we also have an approved soils report that has been coordinated by our soils engineer with the city grading department.
I'd like to just add one more thing, that the appellants, they have discussed their concerns about the site stability or the slope stability, but one of the appellants, Cody Horn, has actually been doing work without a grading permit, building a wall without a permit, and her property is under an order to comply. So I feel like the appellants should take their own advice if they're concerned about the safety of the hillside, to follow the procedural rules in place to guarantee the safety of the community.
Carolina Abrego Pineda. I just want to add a few words. This project is by right. The proposed house will not exceed the allowable floor area. And actually, we're building a two-story home with the idea to not block the visibility, and that's why we have a little more of excavation to consider the neighbors.
And with respect to the property, Clark Bronstein here, I'd like to point out as well, the subject site at issue is over an acre in size. It's one of the largest lots in the area, so the home that's being built is proportional to the lot area ratio to residential floor size. So this is a CEQA exempt project. The city should adopt the findings of the Board of Commissioners as well as the staff recommendation.
Thank you. George Bronstein spoke, right? Or George Bronstein?
Good afternoon, Councilman Weezer and the committee. I'd like to thank you, Councilman, for all your community service, for all your help to the community, for your help for people like Dolores Mission and the Hollywood Museum. Thank you so much. I've lived a few minutes from the project for 50 years. I've raised 4 children there. I walk my little Havanese dog, Javier, on Tiger Tail on a regular basis. There's a tremendous beautification of this area going on. LeBron James just bought a home on Tiger Tail. The head of Intel has just bought a lot and he's going to build a home. So it's one of the more beautiful, architecturally beautiful development areas in the city, and it's attracting tremendous growth for our community. I just want to say that in the 50 years that I've lived there, and it's been noted, there's multiple projects going on. I go up and down these streets every day. There's no impact. It's a regular sized street, and the community is being enhanced by the development, not suffering from it. Thank you very much.
Thank you. Ignacio Rodriguez. Gaspar already spoke. Mitch Ryan already spoke. Yeah. Council District 11 here, a representative from Council District 11. Right here. Did you contact Council District 11? Okay. Are there any questions or comments on this item? So to the staff, you've heard some public testimony. Do you want to respond to any of their points they've made? And what about the cumulative impact of other projects on the street? How many projects are there? We don't know.
This is Debbie Lawrence, City Planning. These get approved by the Board of Building and Safety Commissioners, and we take in cases and do categorical exemptions on them, but we do not have a tracking method. They are available on Navigate LA, though, so we do have maps that show where they are occurring, so the information is available.
Okay. Sir, do you have an answer to that question?
Wanted to respond to something you had asked.
Yeah. Go ahead.
Yes, so right now, Tiger Tail actually is 30 feet wide. There are 6 current projects going, which were total teardowns or renovations. When there's dumpsters, 40-foot dumpsters on each side of the street or even on one side of the street, it's difficult to pass. It's just incongruous with the area as far as the size of the home and the impact it will have. But right now, Tiger Tail is very, very difficult to travel on because of all the projects. So if this project could be set back or delayed for a few months, or the scope of it would be reduced, it would be greatly appreciated. Thank you.
And we don't know where Council District 11 stands on this. Okay, let's hold this item on the desk for a moment and go to the next item, please. Next item.
Next item, Councilman, is also a haul route appeal by the Doheny Sunset Plaza Neighborhood Association. It's to export 2,100 cubic yards of soil at 1565 North Houseman Terrace in CD4. The appeal appeal, Councilman, on this item has been withdrawn by the applicant.
Oh, the appeal has been withdrawn?
Yes,
Okay.
sir.
So
Terry
we,
Kaufman, Messiah City Attorney's Office. So given the late hour of the withdrawal, then the committee should just deny the appeal.
okay, so we'll move to deny the appeal. There's a speaker card. And yes, we do have speaker cards. All right, let's go there. Sorry about that. Brad Keith and Peg Lessinger. Brad Keith here. Okay. Oh, yeah, Peg, got it. Peg Lessinger.
Hello, my name is Peggy Lessinger, and I reside at 1570 Haslam Terrace. There were several other members from our neighborhood planning to come today, but they were misled by Doheny Sunset and thought this had been taken off the agenda. At any rate, I'm also a member of Doheny Sunset homeowners. I'm an adjacent neighbor to 1565. The impacts listed in the Doheny Sunset homeowners letter are not fully addressed by the agreement between Doheny Sunset and the developer. What we are concerned about is the cumulative effect on our very old private street. There's two major evacuations and construction projects at one end of Haslam. The one we're talking about here is over 2,000 cubic yards to be hauled. And there's another project right behind, also a new construction with a lot of hauling required. Both are adjacent to me.
Thank you.
Am I done?
Yes, every person has 1 minute to speak. Thank you.
Hi, again for the record, Elliot Thompson, representing Brad Keith. I have about 4 or 5 neighbor support letters that I'm going to leave with the clerk for you to take a look at. There are a lot of neighbors in the nearby vicinity that do support this project. There are not 2 projects going on. The other project was withdrawn, so only my client's project will be proceeding. Furthermore, you are just hearing the issues of the haul route and whether or not Building and Safety erred and abused its discretion in approving the haul route for 2,100 cubic yards. With that, I want to point out Ms. Emma Howard is here from CD4. Should you wish to speak and hear what the council office has to say. But we've been working with the neighbors and the neighborhood for several weeks now, actually several months now, and we came up with a number of additional conditions above and beyond what the city imposed on our project. We've agreed to those conditions, and one of the conditions actually directly addresses the issue of the roadway, Haslam Terrace Road, which is a private road. We've agreed to document the current conditions of the road before any construction happens. We will again document the conditions of the road after construction has ended, and if there is any issue or any repairs that need to be done, we will make sure to take care of whatever the issues are with the road. And like I said, we have been working with CD4 on this. They're very aware of what we've offered and where we've come, the place where we've come to an agreement. And like I said, we will continue to speak to the council office and make sure that they're aware. Thank you.
Great, thank you. So on this item, we are denying the appeal so far as it has been withdrawn. Any objections? Seeing none, so ordered. We could call back to order item number 11. And for item 11, the appellant's points are one, that there's documented and undocumented slope failures. Can you address that, please?
In the soils approval letter, it does address those issues, and it requires that they provide shoring plans to the grading division, as well as 50 other, let me see actually the number of conditions, 59 conditions to be applied with regards to the grading and structural plans. That will then be approved by the soils engineer for the project and the structural engineer, and those issues would be addressed.
And How about the neighbors? Any significant impact to the neighboring properties?
No, this is a really large project site as indicated by the applicant, and as such, it would not have an impact on the neighbors. And for any issues with regards to neighboring slopes, the shoring plans should satisfy that.
Okay. One of the appellants, you had some requests at the end of your, what was your request?
We're requesting that the CEQA not be waived, that environmental impact report should be made, or this...
You're requesting an EIR, correct?
Yes.
Okay, that, you had some requests at the end as well. That was it? Okay.
Also, to consider reducing the amount of cubic footage that would be able to be removed by 1 to 1/3, so more in line with 1,000, which would be more in line with what's the size projects that are done in the area.
Our community is actually really unique. It was built right after the war as a cooperative with 350 lots. They're all very small houses on very small lots. This is one of the largest lots in the community. That's why he's trying to max this out, but it's not consistent with the texture of the neighborhood.
I get it, but you understand what the only thing before us is the haul route, not
I do
the
understand
development,
that.
not the
But
project
the
itself.
300
and how big that
truckloads
is. Yeah,
is beyond
got it.
comprehension.
Okay, thank you. With respect to the EIR, similar projects like this are dealt with M&Ds, so the M&D sufficient for this, you would concur, building and safety?
President Huizar, it's a categorical
Exemption,
and
okay.
the standard for what I think they may be arguing, whether or not there are exceptions to the exemption, is just substantial evidence.
Yeah,
So you don't find substantial evidence, you don't even get into that further.
So other similar projects like this are dealt with categorical exemptions or M&Ds?
This is Debbie Lawrence, City Planning. They are dealt with categorical exemptions because this is considered infill and it's a single-family home. We wouldn't typically do an MND for a single-family home except that it's triggered by the need to do environmental review for the haul route, which is heard by building and safety.
I got you.
Yeah.
Okay. Doesn't reach that threshold. Okay.
Right.
And I would assume that if we cut it down significantly by a third, that would severely impact the project itself, right? Correct?
Yes, that is correct. That would be looking at possibly redesigning the project, so it would change the project description.
Yeah, okay. Okay, well, any other questions or comments? Okay, I'll move that we deny the appeal and sustain the application to export 3,000 cubic yards of earth and adopt the related CEQA findings for the project. Any objections to that? Seeing none, so ordered. Thank you. Next item.
There are no further items, Council.
Okay, we have general public comment. Thanks. Critic. Spindler Wayne. I want to remind you, Mr. Wayne, that these are items having to do with planning and land use. Any other items you wish to discuss here are considered a disruption of this meeting. Sir, can I finish? That's your first warning, sir. Let me finish. Any other discussions about anything else, you would be asked to leave if it's considered a disruption to this meeting. Thank you.
I can't criticize the elected officials at the meeting. How about that, Mr. Bob? Can I do that?
Sir, you are not speaking to anything having to do with land use and management. You are being expelled from this meeting. Thank you very much. You were given sufficient warnings. Sergeants, can you show Mr. Spindler out, please?
Mr. Blumenfield, help
Sir,
me, Mr. Blumenfield.
You are asked to leave this meeting. Thank you.
I can criticize the elected official, can I?
Joe Jimenez. Mr. Herman, you heard the warning to Mr. Spindler. You have one warning already. If you disrupt this meeting by being off topic, you would be asked to leave as well.
So, regarding the so-called dangerous slope issue, I like to remind the city's liability when I brought the Department of Justice against a specific property at 42 or 2400 Verde off of Soto Street. And it is a responsibility of this commission and those associated with Plum to do your goddamn fucking job to secure slope failure. Don't bring people in here in argument about their fucking property. Do something correct, politically correct, and ensure that the public safety comes first when your fucking slope comes down, like they would say, on a high mountain comes down the slope. Now we got a failure, who's gonna cope? You dumbass Weezer. Fix the fucking sidewalks and streets and our infrastructure, you dumb
Thank you.
lame ass
Time is up.
motherfucker.
This meeting is adjourned. Thank you very much.